Hi there. Thanks very much, and thank you for attending today's webinar. We're happy to present Marijuana in the Workplace program. Had lots of questions come up about this topic, and we'll be looking forward to hearing what Mark Knoth has to say about it. I want to let you know that if you do want to apply for continuing education credit from SHRM or HRCI, you will do that from the SurveyMonkey evaluation that we'll send to you separately following the webinar. That's the only way that you can get the credit. I want to also remind you that we have a Best and Brightest National Summit, our very first, September 15th to 17th in Chicago. So we'll look forward to seeing you, many of you there. This program is being presented by Best and Brightest Companies to Work For, but it's being co-sponsored by Mish Business and Corp Magazine. So there we have a wide variety of people on the call today. I now want to present to you Mark Knoth. He is an attorney with the firm of Kerr Russell based in Detroit. He leads the firm's labor and employment practice group and represents management in all aspects of workplace law, including advising and counseling employers. He defends companies in litigation and represents them in collective bargaining. Mark has a unique perspective on employment law, having run his family's manufacturing firm and growing it in sales and then selling it. And he learned to appreciate what's involved in owning and running a company. So we're very happy to have him with us today. Mark, go ahead and take it away.
Good morning, everybody. I'm very pleased to be here to present to you on this very interesting topic. I would just like to say that it's obvious to everyone, but I'm going to say it anyway, that the culture on marijuana use is changing before our very eyes. We're seeing a paradigm shift as it comes to this particular drug. If it hasn't happened already, an employee will soon ask you whether or not it's okay to come to work under the influence of marijuana, or is it okay that they use marijuana on the weekend and work there? Hopefully, we'll help you answer that question if you haven't received it already. I hope we can clear things up by the end of this webinar, and you'll have a better idea of a lot of the issues and be able to put together an action plan to ensure that your company, your organization, stays out of trouble and essentially does the right thing as it relates to marijuana in the workplace. We're going to go through some of the background of the federal drug laws, just so that you understand that there is a major conflict between the states and the federal law, most states anyhow. We're going to talk primarily about Michigan law, but I'm going to attempt to touch on some of the other states because I realize that we have others here from other locations. And in the event that I don't have the answer, because I don't like to shoot from the hip, I'll be happy to correspond after the fact and get you an answer. We're also going to talk a little bit about the interaction of the ADA and some of the marijuana laws. And lastly, it'll be in this order as well, we're going to talk about some of the key considerations in company policies. And if it's not about a specific provision you should have, it may cause you to think about things as an organization that you may want to consider going forward. Because a lot of this is really what the company is choosing to do. What does your company want to do? Who does your company want to be? It's a very complicated topic. I'm going to move sort of quickly, and I'll be happy to, as I said, assist you after the fact. But there will be an opportunity for questions and then after that as well. So first of all, why do we test for drugs? Why do we care about drugs in the workplace? Companies have long sought to prevent drug use in the workplace. Well, number one, it's illegal. It's illegal under federal law. It's been illegal for a very long time. Number two, it presents an unreasonable safety risk. Studies are all over the place about the impact of impaired individuals, particularly in what are called safety-sensitive functions where machinery is at issue, heavy machinery, things of that nature, unreasonable safety risk to life and limb. And the third one would be liability and cost. Risk of liability. Somebody gets hurt, the inebriated person or the person under the influence or impaired causes some sort of an accident, somebody's injured, there's liability, somebody's in a vehicle or a truck, they get in an accident, it's catastrophic, there are liability issues, which for companies, not to be crass, but it comes down to cost. We're operating businesses and, we have to remain profitable and stay functioning. Drugs have long been believed to have a negative impact on the workplace. There's a study I want to point to. It's a 2009 study for the American Council on Drug Education. It says that substance abusers, not just marijuana, but substance in general, compared to non-abusing coworkers, are 10 times more likely to miss work, 3.6 times more likely to be involved in on-the-job accidents, 5 times more likely to file a workers' compensation claim, and 33% less productive. That was in 2009. We can only imagine with the increase in drug use and the legalization of drugs in many states that is going to only increase. The problems are only going to get worse. In the past, employers have dealt with drug use by basically testing applicants, screening out the potential abusers, and responding with testing where the opportunity presents itself, either post-accident, maybe after a return to work, or in some cases even random. But that can be a little bit aggressive, and many employers choose not to do that. What are the employee concerns? There are privacy concerns. Some states have laws. Michigan does not, but some states have laws. Illinois, I believe, has a law that says that employers cannot make decisions based on someone's personal activities. They're entitled to their privacy. They want to be able to do what they want to do on the weekend. They don't want the company to regulate them on their Saturday when they're hanging out with their buddies or their friends, girlfriends. There are also concerns about a test's accuracy. Not every test is accurate, and as we'll discuss in a moment or two, particularly with marijuana and determining whether someone's impaired at work or under the influence, there isn't really a really great test to prove someone's impaired at work at that moment. The technology is not here yet, although there has been some discussion about a company that's working on a breathalyzer type machine that would detect marijuana usage, but I haven't seen any further information on it. Of course, employees are worried about the disciplinary aspect. They don't want to lose their job. And in some cases where somebody has a health condition as it relates to medical marijuana, employees are concerned because they have to choose, in their view, between their health or their job. And that becomes a very difficult situation where medical marijuana is at issue. I hadn't thought a lot about, marijuana usage or how it really comes and impacts the workplace. I write policies all the time. I advise clients about policies, but I haven't really had to deal with it, on a one-on-one basis, either, with my company or with somebody, directly involved. So just a quick personal story. Literally a few weeks ago, I was having some work done at my house. Some guys were plastering a bathroom, and had been renovated in my house. And I was talking to my wife, who stayed home that day, and asked her how things were going with the plaster guys. She told me they were taking a smoke break. And I said to her, I said, boy, that's great. They're actually taking a cigarette break outside the house and not smoking in the house. And she told me that they weren't taking a break outside. They were outside, but they were not smoking cigarettes. These guys were having a marijuana cigarette break. I was kind of shocked at first and a little bit worried, but ultimately they did a great job. And I came to conclude that maybe plastering, smooth plastering. Marijuana is conducive to that activity. I don't know. The walls looked perfect, and they were great guys, and it wasn't a problem. So it really made me kind of think about marijuana. I've always thought about it in terms of, it's illegal. It's a federal law, and you're not allowed to smoke marijuana. It's a Class 1, Schedule 1 drug. So it made me really think. Let's talk quickly about not so quickly, about the federal prohibitions on marijuana. Marijuana is listed as a Schedule 1 drug under the Federal Controlled Substances Act. This is the same list and the same schedule that includes drugs like heroin and ecstasy, other horrible addictive drugs.
Mark?
And it's always been on the Schedule 1, marijuana that is. As a Class 1 controlled substance, what that really means is that marijuana is deemed to have no medical purpose, and it's addictive, and that it's also not regulated by the Federal Drug Administration, which, of course, as all of you know, is the agency that deals with prescription drugs, over-the-counter drugs, tests them, things of that nature. The FDA has never been involved with marijuana, and so from a medical marijuana standpoint, it's a little bit troubling. Marijuana is not dosed in a standardized form. As people say, you hear people say that it's much stronger than it ever was. So those are all issues in terms of medical marijuana, which may become an issue from a legal perspective at some point in the future.
Mark, can you hear me?
Yeah.
Mark? People are asking about the slides.
Oh. Yeah, they're coming.
Okay, so you're still on the beginning there.
Yeah, this is more introductory.
Okay. Sorry.
Thanks. Sorry, everybody. Anyhow, so the federal government has restricted marijuana in this country since 1937. It was actually a tax act that sort of restricted the use of marijuana, and then in 1968, the Controlled Substances Act came into play, and as recently as 2016, the DEA, the Drug Enforcement Agency, the federal agency, reaffirmed that marijuana is a Schedule 1 controlled substance. There has been a gradual chipping away at this federal prohibition, though. 2005, the U.S. Supreme Court was forced to address a question in Gonzalez versus Raich. That case, the U.S. Supreme Court held in responding to a claim involving a medical marijuana attempt at a medical marijuana statute in California, that Congress could criminalize the production and use of marijuana even if a state law allows it for medical purposes. There have been a number of federal laws which impact marijuana. I've already talked about the the Controlled Substances Act. There's the Drug-Free Workplace Act, which essentially applies to federal contractors and subcontractors, prohibits the unlawful manufacture and distribution, dispensation of a controlled substance, which includes marijuana, in the workplace. Federal contractors are supposed to they're supposed to comply with the Drug-Free Workplace Act. They're supposed to have awareness programs, and they're also supposed to have disciplinary action for employees who violate those policies. Next on the federal list is OSHA, the Occupational Safety and Health Administration. It has strongly supported drug-free workplace activities by employers. It doesn't require the testing for drugs, but I'm just going to quote from a 2009 statement here. The OSHA recognized that impairment by drugs and alcohol use can constitute an avoidable workplace hazard, and that drug-free workplace programs can help improve worker safety and health and add value to American business. OSHA strongly supports comprehensive drug-free workplace programs, especially within certain workplace environments, such as those involving safety-sensitive duties, like operating machinery. It stops short of the testing requirement. And it applies to everybody's workplace, either through the federal agency or through the state comparable agency. Everybody, if you have a trucking operation that it uses commercial trucking, commercial truckers are subject to the DOT regulations. Very complicated set of drug testing rules that require drug testing, in many cases random testing of drivers. Drivers caught with marijuana in their system are subject to termination. Other agencies, and there are many, the Federal Aviation Administration, the Nuclear Regulatory Commission, NASA, the Marine Corps, the Marine Operations, Coast Guard, if you have barges or something like that, or boat operations in your business, all require drug testing, all prohibit the use of drugs. So the concept of prohibition of drug use is well ingrained in the federal system, and it has been for a very long time. And as we'll discuss soon enough, this conflict with the states presents a problem for state statutory framework. There's also the U.S. Constitution, which says that federal laws are supreme and that they govern over state laws. So all those things put together spell out a situation where the federal government is very unlikely in the past to change its position about drugs. Well, we started to see a shift. Starting in 2013, the federal government started to move away from the strict enforcement of marijuana. The DOJ, the Department of Justice under President Obama, issued a memo called the Bail Memo that said basically that federal resources would not be used for simple crimes involving marijuana that didn't have extenuating circumstances. That began to shift the policy. But in 2017, Attorney General Jeff Sessions under Trump rescinded that rule. In response, the Democrats came back and passed as part of the budget amendment, requirement that federal funds could not be used to prevent states from passing laws restricting marijuana. So really, at this point, we don't know exactly what the future holds. A lot of it's going to depend on the 2020 presidential election. A number of Democratic candidates for president have indicated that they would pass a law to reverse the federal prohibition on marijuana. We don't know where that is. Certainly we're not there now. We only have this statement in the Budget Act. What changed the federal view on this? Public opinion, number one. It's become more mainstream. 1969, 12% of people favored legalization, 12%. Last year, a Gallup poll found that 64% of Americans favored legalization. A much higher number favors legalization of medical marijuana. So it's the will of the people to a large extent. The other issue that's changing public opinion is the revenue aspect of marijuana. It's a $20 billion industry last year in the U.S. economy. Predictions are that by 2021, it's going to be $70 billion. The money is from medical marijuana is not going away. Beer makers, beverage makers, pharmaceutical companies are getting involved in the act. The third issue is that criminalization has not worked. 10% of inmates in the federal prisons are there for marijuana offenses. On average, 15% of them in state prisons are there for marijuana offenses. And one of the more troubling facts about marijuana criminal convictions are that blacks make up four times more likely to be apprehended for marijuana offenses than non-minorities, which is very troubling. So I know there's been questions about the slides. Here comes the first slide. Okay, this is a map, of course. There is a state on here, actually Illinois, that should be dark green now because they're one of the most recent states to pass a marijuana law. Looking at this slide, as a result of the many changing attitudes, across the country, just with the general public, states began, the pioneers in the legalization, of course, Colorado and Oregon and California with respect to medical marijuana. They passed the laws, and we're sort of a petri dish, so to speak. I think that many states who were considering this change, passing a law to legalize marijuana, either recreational or medical, wanted to see what happened. Would there be a lot of social ills? Evidently, it's worked out okay in Colorado, and I know that originally the governor of Colorado opposed it, but he's changed his mind, having seen all the tax revenue they've been able to collect from marijuana. So as the federal government began to loosen up a little bit in 2013 with a Vail memo, which we discussed a moment ago, states began to legalize marijuana. Currently, there are 33 states which, with some sort of legalized, law allowing marijuana use. Recreational use is legal in 11 states plus the District of Columbia. In alphabetical order: Alaska, California, Colorado, Illinois, Maine, Massachusetts, Michigan, Nevada, Oregon, Vermont, Washington, and D.C. They all have laws allowing recreational use. Interestingly, of all those states, the only one that legalized the marijuana use through the legislative process was Vermont. All the other ones were referendums, the voice of the people to some extent. Now, the laws themselves vary greatly from state to state. So if you have multi-state operation, it's going to be very important for you to consult legal counsel about the specific contours of any restrictions. You're going to need policies and maybe addendums to policies that are state-specific. One state in particular has decriminalized. Some other states have just decriminalized it, not necessarily made it a recreational use. They haven't gone that far. Some states have allowed for only cannabis-infused products, and we'll talk more about that in a few minutes. Regarding medical marijuana, it's important to note that a number of states are currently in the process of changing their laws. And specifically, in some cases, doctors under federal law are still prohibited from prescribing marijuana as a medicine. Let's talk quickly about the Michigan legislation. So Michigan was one of the earliest Midwestern states to legalize marijuana. In 2008, voters approved a ballot initiative to legalize the medical marijuana. Now, that particular statute, which was codified, was very difficult to understand. It was written by non-legislators, and still to this day is a little bit vague. It specifically carved out any aspect of employment. Employment was not affected by medical marijuana. In other words, a medical marijuana card did not save somebody's job if they tested positive while at work. They said specifically in that statute that employers did not have to accommodate marijuana use in the workplace. They didn't go so far to say accommodate a disability, but they certainly used the phrase accommodate. Now, some states out there have specific provisions which speak to accommodation, that require accommodation. Some states have specific provisions which say that employers are not allowed to discriminate against employees who've used medical marijuana. The Michigan statute specifically says you don't have to accommodate it in the workplace. It also says you don't have to tolerate employees being under the influence at work. The term under the influence is in the statute, and that is an interesting choice of phrase. Under the influence could be having, some of it in your body system. It doesn't mean necessarily that you're impaired or unable to do your job. It sort of speaks to in favor of a zero-tolerance policy. Now, interestingly enough, it's not defined in the statute. In 2016, they amended that medical marijuana statute to basically fix some of the mistakes that were contained in it and set up an arrangement where medical marijuana businesses could be started. 2018, marijuana was legalized for recreational use, passed in November of 2018, effective December 6th of 2018. 10th state overall to legalize recreational use, first state in the Midwest. Okay. Well, so here's a quick summary. Let's look a little closer at the Michigan statutes. The Medical Marijuana Act, as you can see, you're not allowed to. You can discipline an employee. The statute specifically says no accommodation and no accommodation of employees under the influence at work. Let's take a look at the recreational statute, the one right below that. This law is 4 pages long. Again, it was a referendum. Legalizes the relationship marijuana by persons 21 years and older, allows marijuana use for employees 21 and older, legalizes hemp and marijuana derivatives, and licenses establishments and provides for collection of taxes. It's going to be some time before all of the regulatory aspects of that recreational marijuana in Michigan are released. The state's commercial system is not yet up and operational, and regulators have, I believe, until the end of this year to finalize the business aspect of the marijuana law. There's no word yet on whether or not the regulators are going to provide a definition of under the influence. So at this point in time, we're forced to determine what that means. Again, the difference between under the influence and impaired could be significant. The term impaired suggests someone is using at work, similar to a driving statute or a drunk driving or a drunk driving under the influence. There is no standard in Michigan and many other places for what it means to be to be impaired by marijuana. And at this point, there's not a great test for that, as I said earlier. So it remains to be seen, either through regulatory action or through case law. There may be a question as to what the term impaired means, and or not the term impaired, but the term under the influence. Marijuana is illegal under federal law, despite the Michigan statute. But the attorneys in eastern and western districts of Michigan have said they're not going to focus on the prosecution of marijuana users or low-level offenders unless there's some sort of aggregating factors. I think what that means, a drug dealer, some sort of other violent crime associated with marijuana use or delivery and things of that nature. The governor of Michigan has said that she intends to grant clemency to many drug offenders in state prison or people with drug convictions as well on their record. She said that as part of her campaign, but as of yet, nothing has happened in that regard. What rights do companies have after the recreational and medical marijuana laws? The Act, of course, doesn't require an employer to permit or accommodate marijuana use in the workplace. It doesn't prohibit the company from disciplining or discharging employees for violating a workplace drug policy. It doesn't prevent the company from taking adverse employment action because the employee was working while under the influence. It does not permit employees to consume or smoke marijuana where it is prohibited by the owner or occupier of a managed property. So I assume that if you're a company and you're in a leased space and a lease says that you can't use marijuana, I suppose that could be carried through. The Act also does not prevent an employer in Michigan from refusing to hire. Now, this differs greatly from other states, and in fact, it's the trend. The trend across the country has been to stop doing pre-employment drug testing. With the tight economy, with the difficulty finding qualified candidates, and the changed approach to marijuana, pre-employment testing has not been a priority for many companies. Refusal to hire is okay in Michigan. In fact, the Court of Appeals has approved that. in many ways, the Michigan statutes don't really require a lot of policy changes to company drug testing policies that are, zero tolerance. There are specific carve-outs, and that's essentially, in a short answer, if a company didn't want to do anything, that was a possibility. In fact, recently there was an article in Crain's Detroit which talked about just Michigan in general, that many employers, including Ford, Edison, CMS Energy, and a number of others, are simply not changing their policy. They're still having a zero-tolerance policy. Now, interestingly enough, those companies are all manufacturing companies, and those jobs are all highly sought after. In some cases, we're seeing that, particularly in hospitality industry, some employers are ending the pre-employment testing procedures so that, there can be more of a more people may be interested in finding a job there. It's sort of an enticement to be employed. So there have been some cases decided in Michigan, nothing really too earth-shattering. I'm going to just touch on those quickly. This first case, and there are only three major ones, not even major. The first one, Nebraska. This case was a Michigan case that said essentially that if an employee is terminated for using marijuana at work, if they're terminated pursuant to a drug testing program, and only marijuana, that they're entitled to unemployment benefits. And that was a significant case. An individual can't be penalized by another statute for marijuana use. That's part of the marijuana statute. The second one, Epley versus Lansing. This is the case I was briefly referring to. This case was a public sector, so it was a city employer. That's a case where a person failed a pre-employment post-offer drug test, and the employer decided not to hire the person. That person sued and lost the case, just basically reaffirming the concept that that you can refuse to hire somebody for marijuana use and failed drug tests. Federal court case law. This Walmart case is fairly interesting. This was a very early decided case shortly after the medical marijuana statute was passed in Michigan in 2010. This case involved an employee who was a model employee at Walmart who had sinus cancer. He was a sinus cancer survivor. And he was using marijuana to, I guess, assist with his appetite or something related to his cancer treatment. And when he was asked to give a drug test and tested positive, he was terminated. The court, in that case, decided to uphold the termination, said it wasn't a violation of public policy, and said that companies had the right to make the termination decision. This brings up a very interesting question and an interesting point about the ADA. Under the Americans with Disabilities Act, there's an obligation to accommodate disabilities. That specific issue wasn't involved in this case to a great extent, but under the ADA, many courts have held, and across the country it's been challenged, that because of the federal prohibition and the fact that the Americans with Disabilities Act is a federal act, that marijuana use cannot serve as a basis for a claim. Now, that's not to say that a specific case can't be made out for disability discrimination for somebody who happens to be using marijuana, but if they're terminated for marijuana use, that sort of obviates the argument that they were terminated for discriminatory reasons, although there is a possibility that that case could be filed. And some states require accommodation of people who make a case for medical marijuana use. So that's an issue that has to be closely watched, not just in Michigan, not so much in Michigan until we get more clarification at the federal level, but definitely outstate. Let's talk for a second about a unionized environment, marijuana use in a unionized environment. This case, Wellington Industries, is actually a case that I handled. This is my case. This was a situation, it had a tricky set of facts. It was a 25-year employee, was a union steward of this manufacturing plant. The policy was a little bit odd because it required that the company prove that the employee was impaired at the time of the drug test to support the use of marijuana in the workplace. And it was a fairly hotly contested termination by the UAW. But ultimately, I think due to the severity of the accident, you know, and the fact that, you know, this was not the first time this person had tested positive, because the employer had a fairly progressive, you know, two-strike policy for marijuana use, the discharge was actually upheld. Now, what about a unionized workplace? Drug testing in a unionized workplace, in many cases, drug testing itself is deemed a mandatory subject of bargaining under the National Labor Relations Act. And what that means is that in order to have a policy in place with respect to union members, an employer has to bargain with the union over that language. Employers can't simply implement that kind of a policy across the board with the union unless there are some other things that are at work in the contract. Maybe the contract before the union came on board, that union the drug testing policy was already in place. Some of you may have those types of situations. Now, if you have a drug testing policy and you look at it and it looks as though the policy as it's written in the contract is not compliant with your state's particular statute, it may be necessary to modify that policy. Or you may want to make a change that's not necessarily required by law but is preferred. You know, if it's a legal change, the contract should conform to the legal requirements of that state. But if it's something you want to have but is not required by law, you're going to have to sit down and bargain with it over with the union. So that can really, you know, make it difficult to modify policies, change, and implement policies. I'm in the process right now of trying to get a policy put in place in a unionized operation. Of course, if it's a federally mandated policy, for example, truck drivers, well, then it's something that's required by law and it should be okay under the contract. There's case law to that effect. What about applicants? What about pre-employment testing in a unionized workforce? Applicants typically are not union members and not governed by the contract, but of course your contract language is going to determine that. But typically pre-employment testing is going to be okay in a unionized workforce before a person becomes a union member, unless you're in a state that prohibits that or frowns upon that. The other question is there a management's right clause where the union would have waived the right to bargain over that sort of a policy? The determination of what you can and can't do as it relates to drug policies and testing in a unionized environment is going to depend a lot on your union contract, the language of the collective bargaining agreement, and the applicable case law in your circuit or board law. So that is an interesting question and one that needs to be carefully analyzed before changes are made to a contract. I'm having a hard time moving slides here. Just a quick summary of the Michigan law. We've pretty much already covered this. The first one is the Medical Marijuana Act, and the second one is the Recreational Marijuana Act in Michigan. We've sort of already talked about that. I'd like to move on to the next slide. So aside from marijuana, there are many types of cannabis products that are not smoking marijuana. They're derivatives of it. Things that people use for creams and oils, for pain, some beverages and things of that nature. They're not derived from hemp plants, and in a lot of cases, there are much lower THC, the active ingredient, in these CBD products. So they don't necessarily show up in a drug test as being to a level that will show up. A lot of times they have less than this 0.03%, not enough to appear on a 5-panel. But if somebody uses it a lot and uses it often, it could show up. So is that something that could trigger a termination if somebody's using a cream or lotion for pain? Is that an argument we'll face if we terminate an employee? Is that, marijuana use? At least in Michigan, a policy statement was issued saying that CBD products is not considered marijuana and will not be regulated as marijuana because it's so light in content of the active ingredient of THC. So this is a very open question right now, not only in Michigan but across the country. These products are being produced, mass-produced, and significant usage could result in a positive drug test. How does your policy deal? How will your policy, deal with that going forward? So, just in a quick summary, marijuana is still illegal under federal law. Michigan employees are advised to maintain a drug-free workplace. Ought to talk about the policy should deal with circumstances which will warrant testing, define the products that are being prohibited, include a timeline for testing, and any medical exceptions should be identified in the policy, such as a medical marijuana card or something of that nature that the company may choose to implement. Also needs to show the consequences of a positive test. Some alternatives might be, having a 2-strike policy or reassigning employees, maybe creating a different standard for impairment, but we'll talk a little more about that in a second. So let's talk about quickly the detection windows for drug tests. Urine, person can utilize marijuana products and it can still show up in a test up to 30 days later in a urinalysis. Saliva test, 1 to 3 days. Hair test could be 3 months. And then there's the blood test. That can last 3 to 4 hours. And if you're one of those companies that wants to allow people to use marijuana on the weekend and test for impairment, you may be a candidate for doing a blood test. Now, what the blood test that is used is called, what they look for is something called active THC. And it's a fairly controversial standard for impairment. In Colorado, they have adopted that as a standard of 5 nanograms ng per liter of blood of active THC as being the touchstone for impairment. There are a lot of studies all over that say that's too high or it's too low, that it's not accurate, that it doesn't show current use. There are criticisms that people who don't use marijuana a lot would show a higher level, and people that use it every day might not be impaired at work. So there are many problems, sort of as we talked about at the outset, as it relates to testing for impairment. No guidance in Michigan, very little guidance in other states. Colorado is one of the few states that follows this particular blood testing standard. So that is a very open area. What is the test for impairment? Next slide, relating to the ADA and marijuana. So under the ADA, you can prohibit illegal use of drugs and alcohol in the workplace. Use of medical marijuana is not considered a reasonable accommodation for disabilities in the workplace. Again, as we've already discussed, that has been challenged, by a number of courts across the country, and some states do require accommodation of medical marijuana disabilities or conditions. One of the problems we've had here is that in Michigan, at least, as soon as the medical marijuana was passed, many employees were finding it quite easy to get a medical marijuana card. So the concern with some of the manufacturing clients that we have was, before we knew it, everybody who wanted one would have a medical marijuana card. There wasn't a very stringent test for the medical condition that required it. And, the concern was that it would eventually be a recreational use rule. So that sort of persuaded a lot of employers, or at least a lot of my clients, to say, well, we're not going to accept medical marijuana cards in the workplace. That sort of attack could lead to problems under the ADA if a disability is at issue, but that's a risk some employers may be willing to take. But as we said, until a federal law changes, we are where we are with the ADA on the federal side. I wanted to dive a little bit deeper into what we should do as employers with respect to our policies. So here were my thoughts. In Michigan, it's okay to have a zero-tolerance policy. If you want to leave it that way, if you don't want to change your zero tolerance, if there's any sign of marijuana, if you don't pass a blood test or a 5-panel test that shows you may have used it, 20 days ago, and you still want to terminate somebody, there's nothing that prevents you from doing that in Michigan at the present time. But this isn't the end of the story. I mean, there are a lot of changes that are happening at the federal level, and the courts could have something to say about that sort of a practice going forward. Changes at the federal level would result in greater difficulties under the ADA if marijuana is no longer a Schedule I drug. If it's not illegal at the federal level, ADA concerns would come to the forefront. So what are the trends? Well, what is certain is that marijuana use is increasing significantly and on a regular basis. As a practical matter, there will be increasing numbers of positive drug tests. So as people begin to use more drugs, you're going to see more people with positive tests. And it's going to be higher all the time, according to Quest Diagnostics. According to Quest, since 2014, positive drug tests are up 16% on average. And since 1984, according to Quest, drug use among workers has doubled. So, policy changes. First of all, you should have a written policy, and you should review the policy. You should review your specific policy language with legal counsel so that you can look at the language in comparison to your specific state requirements. If you have multi-state operations, you're going to have to make sure that the employees who are stationed in other states are being held to a policy that's compliant with the law of that state. When you look through your policy, you need to look for the phrase illegal drugs, because marijuana, under the state statutes at least, is not an illegal drug. So you may want to modify that language to specifically state that you're going to test for marijuana, not just illegal drugs, and that it's inappropriate for employees to use illegal drugs. Although still illegal on the federal level, they're not illegal on the state level. You should also take a look at your smoking policy. Sometimes smoking talks about not smoking tobacco products. Well, it should just say smoking in general, or even state marijuana products as well. The policy should address the issue of medical marijuana cards. It should address how the company is to address marijuana cards. How is the fact that an employee has a marijuana card going to be communicated to the company? Is it going to be in advance of a test? Is it appropriate to do it in advance of the test? Who should receive the information about the medical marijuana card? And what will be communicated? Certainly as an employer, we don't want to know, if we can avoid it, about a specific disability that an employee has. We would simply like to know that they have a legitimate card if we're going to accept the card. Again, the card doesn't have to be accepted, at least in Michigan, for employment purposes. Your policy should have clear testing procedures. They should be set forth, describing exactly how the process will occur. The employee should really be made aware of the testing procedures, not only during their employment in the course of a handbook or maybe an annual notification, but I think that a lot of employers go wrong and get failed pre-employment tests when they don't indicate in their posting or their job offer that drug testing is going to be required, or even before the job offer. Employers should make employees and applicants aware of the consequences of a positive test. The policy should state that clearly. Unionized workforce, we've talked at some length about the contract, how it should be analyzed and needs to be reviewed. It may need to be bargained to make a change to that policy. Companies should review, as part of their drug testing policy and procedure review, they need to review their agreements with their vendor. Is the vendor getting the appropriate authorization from the employee before they agree to testing? Typically, if you use a very large testing company, that more than likely they're going to have very good documentation that an employee has to sign off on. But it's probably important, and I know it is important, to make sure that's in place. The other thing is, you may want to have employees sign an authorization right at the beginning when they fill out their application. The application forms that I give my clients state right in them language about authorizing a test, drug test, and the release of those results. So there's no question that that authorization has been given. Also, I think it's important to have a medical review officer, as part of the testing procedure, review positive test results. If there's a positive test result, you may choose to include an opportunity for a retest. That helps with proof to establish a case if there's ever a challenge to whether or not a person is under the influence or impaired at work. That's the standard chain of custody. That hasn't changed as a result of these legal changes, but it may become more important as we go along. Policy needs to set forth the specific circumstances for testing. A lot of times I'll see policies that don't even speak to the testing. It should indicate in the policy, are we doing pre-employment? Are we going to do reasonable suspicion? If there's reasonable suspicion testing, then what's going to serve as the basis for reasonable suspicion? I would recommend that reasonable suspicion be based on some sort of articulable facts as opposed to just some drug test. Along those same lines, managers should be, supervisors and managers should be prepared to articulate, what it was. Well, did they smell marijuana on somebody? Was the person acting funny? How specifically were they acting funny? Because the proofs could be difficult, particularly if you're going to be an employer who decides to allow weekend use. We've got to show, you will have to show somehow that a person was impaired at work if that's going to be a corporate decision on your part. Supervisors should get some training, or at least somebody in HR who can make a reasonable suspicion determination. That certification certainly helps if the case goes and is litigated in any way. The other issue, if you have a DOT driver, someone who requires DOT testing, you should probably have a specific testing policy for those drivers, a DOT testing procedure. The DOT regulations are very specific as to the testing protocols. So we typically prepare separate policies for drivers. Policy should specifically state what happens in the event that a test result is adulterated. Again, according to Quest Diagnostics, with the greater marijuana use, companies are seeing and testing facilities are seeing quite a bit more adulterated or attempts to pass tests through fraud or some sort of adulteration. That's another reason that the medical review officer is important. They have protocols to determine whether or not there was some adulteration to the drug testing sample. The other question would be, is a refusal to cooperate considered a positive test, or what are the consequences from a refusal to cooperate? The other question would be, or the other thing that's really important about a drug testing policy is to be consistent in the way you address positive tests. You may not choose to terminate an employee after the first instance, but whatever the choice is, it needs to be consistently set forth in the policy. It's important to determine what the standard is for impairment. If you're going to show that somebody needs to be impaired at work to be terminated for a positive drug test, the policy has to set forth the standard for impairment, or should identify a standard, whether it's the Colorado impairment, whether it's based on observations. It's important, I think, that impairment or be identified, what the standard is. I think that you need to be prepared to modify that policy going forward as case law develops. Marijuana law right now, specifically as it relates to employment, is developing, if you haven't gotten the gist of that already from this presentation. Even more important than simply changing the policy, I think it's really key for companies to decide within their organization what they want to do. Do they want to continue pre-employment testing? It's a tight job market. Big companies nationwide, such as AutoNation, the world's largest, or the country's largest auto dealer, has decided to stop pre-employment drug testing. Does your organization want to allow off-duty use? We've talked about this. If that's the case, you need to come up with a standard for impairment. If you don't have a good standard, you're going to have a difficult time sustaining the termination, and for a policy violation. The employee is going to deny impairment at work, and you'll have a difficult time proving it. Realize, as an organization, that before you decide not to drug test, that marijuana is not the only illegal drug. I mean, there are many substantial drugs, Schedule I drugs, that you should be testing for. So maybe you don't want to eliminate drug testing entirely. If you're going to eliminate one aspect of the testing, there are certain types of drugs that if they show up on the test, opioids, other types of illegal addictive drugs, you may want to retain your zero tolerance policy for. In fact, I think it's mandated in some cases. Do you want to retest employees? Do you want to test some employees and not test others? So within your organization, you may have positions you think are safety sensitive. People who operate machinery, people who drive trucks, people who are placed in some sort of jeopardy or danger. Maybe they're in a position of trust. Maybe they handle financial records. That's not safety sensitive, but it's a position of high trust. But there may be other employees who work in an office. Maybe they aren't safety sensitive. You may choose as an organization not to test those people. Of course, you're going to have to test drivers and so forth if you have qualified DOT drivers, but maybe some of the workers are tested who are safety sensitive and some are not. Of course, the downside of that is there may be a morale issue. But I think that the landscape is changing significantly with respect to this. But whatever you do, I think it's important to identify what a safety-sensitive position is, either in the drug testing policy, which may make it a long policy, but also in your job descriptions. So if you have a job description, maybe one of the items you include in that job description is the fact that the employer thinks that it is a safety-sensitive position. It would also make sense in the policy to retain the discretion or specifically state in the policy that it's the employer's discretion to determine safety-sensitive positions. Unfortunately, there is no cookie-cutter answer to these questions about medical marijuana in the workplace. As I've said over and over here already, that zero tolerance is currently acceptable, but it may be on borrowed time, depending on what happens at the federal level. You need to decide as a business, what you want to be, because at some point it's going to be difficult to hire employees for drug use, off-duty drug use. It will become more and more prevalent over time. I believe that. Views are simply changing. So I think that you have to decide the plan that works best for your organization and implement it from there. Thank you very much. I'm wondering if you have any questions at this point.
Hi, Mark. This is Jan again. Thank you very much for that very informative program. Do you have a policy template that we may be able to share with our listeners today?
Well, I certainly could share one. I am concerned a little bit because we have multi-state operations,
right.
And a lot of it is really going to depend upon what you want to do as an organization. I mean, as I've said already, I think, zero tolerance is okay. Really, what you have in place with some of the accoutrements I described here is probably makes a lot of sense. I can find a standard policy, perhaps, and circulate that to people who are interested in receiving it.
All right, we'll let them know that. And then another question is, can you legally ask someone if they have a medical marijuana card?
You can. The question becomes, and I faced this issue in my UAW case, the company wanted to know up front, everybody who had those wanted a copy of them. The union argued that, that was tantamount to disclosing disability information. So I think it's okay to ask. It's not necessarily a medical inquiry, which of course are restricted under the ADA, but I think that you need to be careful what you ask for. If you ask for information about the medical card, you may get more information than you want. Under the ADA, a company really never wants to know a lot of detail about a disability for fear that they will be painted with making decisions based on that. I think if a company is going to ask those questions, again, a specific protocol needs to be set, and the policy may want to indicate what sort of information needs to be disclosed and when and to whom.
And if you wanted to ask an applicant or a prospective employee, would that make any difference?
Well, again, medical inquiries are potentially problematic, especially with applicants. Specifically, the ADA regulations provide that you can't make any kind of medical inquiries or do medical exams until post-offer pre-employment. So I would be careful about asking that question before an offer is extended. Certainly, if you're going to do pre-employment testing, that issue will come up in short order if there's a positive test.
Very good. And then the last question here is, if somebody is using CBD oil, will that show up on a drug test?
Again, that's not a question that is crystal clear. The drug testing technology for marijuana isn't what it should be based on the changes in the law. As I've said, depending on which study you read, it'll say that, one-time user may show up, or somebody who uses a lot of the oil, and it depends on the sensitivity of the test being administered. So I think that, there is a good possibility that those oils and products could show up on a drug test.
All right. Well, this has been very informative. I have like 3 pages of notes going here. Thank you very much. Again, I want to remind all of our participants that you'll receive from us a SurveyMonkey with your evaluation, and that's where you will apply for the continuing education credit. So, Mark, thank you again. Thanks to Kerr Russell for participating with us today, and we will be signing off now. So thanks again. Bye-bye.
Thank you, everybody.